Hi, my name is Akiva Goldman. I'm the managing partner of Goldman and Associates. And one of the things we've been doing for over 25 years is injury work. Lawyers call it torts, wrongful injury. And torts means a lot of things. It could mean an auto accident. It could mean an assaultive situation where somebody gets hurt in that way. Today I want to talk to you a little bit about slip and fall. Slip and fall is one of the major areas of tort law. It comes about in many different forms. But the law in our state has changed dramatically over the years. Slip and fall can sometimes be a situation where you're in a supermarket and a little kid runs to the aisle and spills a jar of milk. And then you know the story, the little old lady pushing the shopping cart turns the corner and the milk's already on the floor because the little kid just spilled it and she slips and falls and breaks a hip. Is that a case? Is that what we call slip and fall? Well, no and yes. It's a slip and fall, all right, because those are the facts. Is it a case? Probably not. Why not? Because the reason is that the slip and fall is predicated on an act of negligence. It's not just that somebody slips and falls and all of a sudden there's a paycheck. That's not how it works. What has to happen is somebody has to have slipped and fall because of a breach of duty of the premises owner. The premises owner failed to do something that they were supposed to do, or did something wrong that they were not supposed to do. That's a legitimate slip and fall. So in my scenario, where the kid drops the bottle and the woman falls, that's not a legitimate slip and fall because the duty of the store owner to clean up the mess requires that they have some notice. They got to know about it. They have to have known about it, and it had to have been there for a reasonable amount of time. And if they nonetheless fail to clean it up, or if they clean it up and do a lousy job, and then somebody slips and falls, that's a case. That's what lawyers mean when we say slip and fall. It's not just a question of I fell, I tripped over my own feet. Do I have a case? You don't even have to wonder about that. The answer to that is no. Now sometimes it's not evident whether or not somebody has a case. The law has changed a lot recently, and now we have a doctrine called the open and obvious doctrine. The open and obvious doctrine basically was designed to protect insurance companies and to protect the big money lobbyists and corporations in our state. Unfortunately, we have too much legislation that protects them and leaves the little guy with no recourse. Open and obvious was one such development in the law. Basically, open and obvious said, if you have a legitimate slip and fall, but the defect in question was such that it was in an area open to the public, and it would have been obvious that there was this problem if you would have looked, then even in that scenario, you don't have a case. Now, what does that really mean? What's an example of that? Well, suppose we have our slip and fall situation where the bottle falls on the floor and it's there for 20 minutes. And the store people talk about it on the PA and they notice. And everybody knows, they got plenty of notice, and they don't clean it up. And then comes around the corner your old lady with her shopping cart, and she's looking at the aisles, and she's not looking on the ground, and she slips and falls and breaks a hip. Under the open and obvious doctrine, because the milk is in an area that's open to the public, and because it would have been obvious had she looked, you know what that lady has? A broken hip, but no case. Open and obvious kills a case like that, and it's even worse. There were even cases where, a situation where a blind man asked directions from a restaurant employee because he had to use the restroom, and he was told down the hall to the left, and he went down the hall to the left, and the restroom wasn't on the left, it was on the right. You know what was on the left? A door and broken stairs going to the cellar, and he went down there and he fell and he had a serious injury. The court ruled in that case that because the area was open to the public and would have been obvious to a regular non-blind person, that man had no case. Look how far the law has come. from protecting the little guy to basically making it nearly impossible to have compensation because of the wrongful actions of somebody else. Now, the law has tried to correct these problems. The law has tried to get away from the draconian impact of open and obvious and sort of move a little back the other way as the pendulum swings closer to fairness than unfairness. But we still got a ways to go on it. We have now situations where there are exceptions to the open and obvious rule. For example, landlord-tenant is an exception to the open and obvious rule. In a situation where the landlord has a duty to maintain the premises under a statute that tells him he has to, open and obvious doesn't save that person. If he violated the rules because the stairs, for example, were in disrepair and somebody falls, open and obvious doesn't help that landlord. That landlord's going to be liable. Hotel and motel is an exception as well. Hotel and motels, they have a statutory duty to maintain. So if somebody gets hurt in that scenario, open and obvious won't save them. We've also had a lot of the ice cases, a lot of the black ice cases where people slip and fall on ice, but they really couldn't tell it was ice. And the case law has basically said as a matter of law that black ice is not subject to open and obvious because though it's open, by its definition, it's not obvious. You look and you don't see it. So there have been modifications to address this area. Only a skilled practitioner will know if your case falls within the open and obvious and is shut down or if it's within one of the newly carved out exceptions. The only way you're going to know is if you ask. If you've got a slip and fall and you've had a serious injury, call our office. We'll be glad to discuss the case with you, and it'll be easy for us to determine whether or not you're in the case, whether or not you've got a chance, whether or not you have a strong case, a weak case. We'll tell you exactly where you stand.